My Lord, I've had an opportunity to have a look at Ferguson, which I deal with at my computer skills, trying to get a new version of Word to go back to submissions in 2012 have defeated me, so I'll do that this evening and report that this morning. I don't have the skills. So I just wanted to say, as you know, every time you go out, there's something you should have said and didn't say. So I would simply say the problem about being sworn in public or private arises really from the New Zealand system. It's a very public affair. Judges come, Chief Justice sits there, talks about the new judge.
Yeah.
4 or 5 speeches are made.
That happens here now. That happens here now.
Yeah, and it's just never occurred to me that it doesn't happen anywhere else, because everything New Zealand does tends to be inherited from Mother England. So anyway, that's how the proposition arose. Now in Ferguson, I'd make 2 or 3 points. The paragraph 10 of the judgment refers to the amending act, and at 4 says the act shall have effect even though inconsistent with paragraphs 4 and 5 of the Constitution, which of course doesn't happen with the Pitcairn Court of Appeal order. Doesn't say, despite
that's because the Constitution of Trinidad provides for certain decisions of contrary to the Constitution to be ratified effectively by Parliament, notwithstanding the Constitution. So it affects the procedure for legislation.
Right.
But nothing else.
Okay, and then at paragraph 15, where your Lordship discusses the Westminster model and the separation of powers, I mean, what differs in this case is it's the reverse argument. This isn't simply a separation of powers, it's an amalgamation of powers. The legislature and the executive branch have been merged, so it's completely and fundamentally different to this case. And I don't think I have any possible advance I could make on your observations in paragraph 27, or for that matter 28, where you've relied upon the Strand Greek case, which I rely upon too. But what I can say in an attempt to say that this is really distinguishable is going back in my submissions to page 12, where I discussed the approach to this appeal and the Tito case before this board, where there was gross error in the appellate system.
Right.
And the substance of the decision, which we did not discuss any of the details of the criminal appeals. The board wasn't interested in that. We were just dealing with the systemic issues, and the result of it was that 1,500 appeals had been done wrong for 10 years, and that's what I've been saying here. This is a systemic error, and
but it's
nothing more
there
or
is
less.
systemic and systemic. The systemic error in Tito affected the particular cases, didn't it?
Yes, the way the appeals had been done. The systemic errors here are the way the judicial system and the prosecutorial system have been set up.
Yeah.
But nevertheless, the board said, well, you've got to give this a generous interpretation, and the Minister of Home Affairs Bermuda and Fisher case, we don't have the approach of austerity of tabulated legalism, and there's something basic to our system which transcends any particular case, and that's what I'd say here.
Yes, I mean, if you can pull the whole house down, then
Yes.
everything within it is collapsed. But that's the question, whether the points you're making lead to a conclusion, since they don't have any direct bearing on these particular cases, most of them, but whether they lead to a conclusion that really there isn't an acceptable system of justice.
I agree. That's where I'm heading, and it's been the essence of this case from the very beginning.
But some of your submissions suggest that there isn't any law, not just in relation to the administration of justice, but none at all.
Can you be more precise?
Well, some of your
Lordship?
submissions about the Constitution, the validity of the process by which that came to be.
Well, if you look at it in the context of the medieval chains, I mean, what we've got in enacting the Constitution is an imbalance of power between the United Kingdom and Pitcairn, and two junior officials from, I think it was the Commonwealth Foundation, come out to advise them against the Foreign and Commonwealth Office. Well, that is hardly a fair process in constructing a constitution in modern day terms. So I think I'm entitled to comment upon that in an adverse way. But
The time is marching on,
yes, I know,
and you've got an hour and 20 minutes or so, so it's up to you how you divide it up, but we're about 2/3 of the way through your case.
Yes.
So we ought to let you get on, and you ought to be mindful of the limit of time.
Yes, I am. I think I'll endeavour to finish my bit today, and Mr. Edgeler can do part 4
Right.
in the morning if I haven't finished earlier, or and then we'll be on track. So I'm going back to page 98,
Right.
and 99, the bias propositions about, and I'm assuming that the point is relatively clear. The President was setting down a hearing of the Court of Appeal under a statute that was inapplicable. It applied only to the lower courts, not to the Court of Appeal, and he hadn't, I said, he hadn't read the Constitution, which was the only logical assumption that you could arrive at, as he was supposed to make rules.
Well, did anyone point out to him the error when he produced the judgment, or at the time when the argument was being presented?
From my recollection of this, it was a telephone conference, and it was, like many of these telephone conferences, you don't know what's going to happen at the telephone conference, or even quite what you're there for. So, no, I felt uncomfortable with it and went back and challenged it, to my recollection, as soon as I could.
Yes, I get.
And as I think I've said, what I should have said is he not only didn't read the Constitution, but he didn't carry out his constitutional duty.
Well, I mean, everyone was in error. Crown Counsel, it was Crown Counsel who sought the order under Section 15E. You heard it, but didn't at the time raise a point, and the President made the orders.
Yes.
And then you made some robust comments about the President, suggesting he didn't have at least a passing knowledge of the Constitution and legislative framework, regrettably appeared to have little experience or training in constitutional law, was engaged effectively in nothing more than adopting large sections of the Crown's submissions, blindly followed the submissions of the Crown, put no judicial input into his decision.
Yes.
So you were quite
I was robust, yes.
robust. Well, you seem to be complaining that he was what you might call robust or in return, or would you say it went?
I think it went too far, because he's saying, or they are saying, that the submissions bordered on contempt, and that was, I thought, an unfair and wrong proposition, and
bordered on the contemptuous. Well,
yeah.
I don't know whether he meant. It doesn't mean cross the border, does it? It means bordering on, getting near it. And contemptuous is perhaps slightly different from saying it was a contempt.
Well, there was an article contemporaneously in the Botswana from the Botswana Sunday Times about the Botswana Court of Appeal that said the same thing, and the legal journalist said, well, it's none of the Court of Appeal's business to engage in that. You've either got a charge of contempt before you or you haven't, and they shouldn't go down this route because it's a criminal offence.
Yeah, no, I see your point.
And that didn't meet with great approval, and to my mind it was met with ridicule. But anyway, we got to where we were, and interestingly, nobody ever said, the President particularly, yes, I did read the Constitution, and we got to the stage where we did, and I think I put in there that I have at 444. I know it's in relation to New Zealand, but the March 2018 New Zealand Bar Association endorsing the Chief Justice public comments on bullying, that 64.7% have witnessed harassment or bullying behaviour from judges. So it's a hot issue in New Zealand, if not in Pitcairn. And what the problem I respectfully suggest is, I mean, how do you complain about the Chief Justice and the President of the Court of Appeal without being robust? There's no process for dealing, as there is, with complaining about other judges. It goes to the head of the bench and somebody does something about it. But when you're complaining about the two most senior judges in the judicial system, it's a bit hard to know where you go. But anyway, you've obviously grasped...
What's the effect? The effect is that Court of Appeal, as you say, behaved inappropriately. Only one of the members sat on the appeal which we're hearing.
Correct.
That's, though he did sit as acting president, Justice Appeal Potter.
Yes, well, one...
So you say he's...
She. Yeah, that's a she's.
She, sorry, I apologise to her. So that's fatal, is it, to her?
That's my submission, yes, that it's totally fatal. Right. And the matter was... word I'm looking at page 114, the other possibilities for bordering on contempt. The usurpation point, I didn't think it was particularly objectionable. It seemed to be quite the in word to use in the literature that there was there, but obviously President Robertson didn't think so, and that just made matters worse, I guess. But the usurpation and the order of precedence, and I engaged in the discussion of what the Chief Justice of Singapore had said about how a Chief Justice should behave, and probably His Honour's comments, which are 116 and 117.
Is that pages?
Yes, pages. Are more apt to a jurisdiction of the like of Pitcairn than the vastly different United Kingdom jurisdictions. So he was saying, well, the Chief at the bottom of page 116 there, to the people, the Chief Justice is the face of justice.
And this is the precedence point again.
Yes, and the behaviour of the Chief Justice.
Yes, I've got that. Yes.
Yeah, the Chief Justice is the flag piece.
Well, it's slightly odd when you have a Chief Justice and a President of the Court of Appeal. It happens in a number of the jurisdictions which we hear appeals from, and there is a sort of slight uncertainty as to who stands where, because the President of the Court of Appeal normally hears appeals which include appeals from the Chief Justice. Sometimes, in some jurisdictions, the Chief Justice can sit in the Court of Appeal, so you do get a slight oddity.
Yes, I recall President Cook and Chief Justice Eichelborn did their very best not to sit together, and President Cook, the Court of Appeal was divided into two, the criminal division and the civil division, so they didn't have to sit with one another. Well, I understand it happens, but what seems to be happening here was that because President Robertson had been a senior judge in the Court of Appeal, whereas Chief Justice Blackie was a district court judge.
Yes, no, we understand the probable background, the psychological background. You say that they didn't put themselves in a Pitcairn frame of mind.
Yes. Yeah, and matters went wrong there. And it does require a explanation in my submission if you're deferring to somebody else, which didn't happen. And I've addressed probably fully in the written submissions at page 108 the bullying, chilling effect and or intimidation and harassment with the Cyprus case and Nicola and Finland from Strasbourg. And at 459 there's the Botswana Sunday Times point that I've mentioned, and I don't think I need to. I did seek to recall at the judgment at 471 and met with what I would describe as Justice McGecken, who was effectively running the case, although not sitting in the chair, said, I can see where you're coming from, and I got the impression that they backed off even if they didn't recall the judgment. So it moved forward, at least I thought it did. And at page 119, we're really back on the question of how people were sworn in, and there's the comment to be made at 503, because I'm aware that my learned friends seem to put much weight on the de facto doctrine. Even if you weren't sworn in properly, you're de facto in office and that cures all. And I prefer the approach of the Federal Court of Australia in relation to a constitution there which says no, you can't use the de facto doctrine in a constitutional situation, and that the Coppard case and the Commissioner of Excise in your domestic jurisdiction shouldn't be authoritative without considering the Australian approach. Question cannot be resolved at 503 by ignoring the alleged want of power on some basis of colourable or ostensible authority alone, as will be necessary in this case on the basis that the bare fact that the purported exercise of a power is to be accorded some constitutional significance. So if the Constitution requires you to be appointed and act in a certain way, then that's what the Constitution, that must be followed, and remembering that the Constitution is supposed to be the supreme law of Pitcairn. And then the withdrawal of the case from the President. I did file an extensive set of submissions, what I recollect about 40 pages, saying he shouldn't sit, and he, without giving reasons, decided he wasn't going to sit and never provided any reasons. And I say that Russian case that I cite at 507, which my friends say, well, it's a different situation. Well, every situation is different, but if you're going to change the constitution of the court, then you should give reasons why you're changing it.
Was that really so? I mean, you filed 40 pages of submissions urging his recusal, he acceded to it, and you now complain that he
Well, I don't
did
know
so,
that.
or the way he did so.
I'm not sure that he did accede to it. He may have just taken the position that there would be less stress all round if he didn't sit. He didn't say, I'm recusing myself.
You invited him not to sit, and he didn't sit.
Yes, but why didn't he sit? Because
Presumably because he saw some force in, or at least some potential embarrassment. Are you saying that it would be improper for him to withdraw unless he indicated which of your submissions he accepted? I think that's what you are saying.
yes, that's what I am saying, because I'd have a stronger point here, wouldn't I, if he said, I'm recusing myself.
But forgive me, you asked him not to sit, and he, for whatever reason, didn't sit. Is the complaint now that he should have sat?
Oh, no.
It's simply that he did, I say simply, but it's that he didn't give reasons. What injury has that done to Mr. Warren?
Oh, well, that, Lord Hughes, is the question that I address at 509.
Thank you, 509.
In the Russian case, and that, and also at 510, the Bangalore Principles.
Wasn't that a case where the parties weren't happy with the change of personnel?
Yeah.
Well, I think...
You'd positively been asking for it, you see.
No, I was asking for it, but if he'd said, I'm recusing myself, then I could be standing here and saying, right, he shouldn't have sat in the earlier cases, and my point is more powerful.
Oh, I see. Right.
He
Okay.
doesn't
So
say.
he's deprived you of an admission, effectively.
Yes.
Right.
Yeah, and I know.
Saying, all right, I accept I was apparently biased.
Yes,
Right.
or had the appearance of it.
Right.
Right, and then we move to the judicial review, which we've had some exchange about with Lord Sumption, and I need to convince the other four of you, I suspect. The Supreme Court did not treat the appellant case as an informal judicial review when it was invited to at the very beginning in Lady Lovell Smith's judgment. And what I think the issue, which we didn't really get to grips with a little earlier, is that if we went down the judicial review track, there's going to be no right of appeal to your lordships. If we go down the constitutional track, we've got the right of appeal in section 25. So that's why I wasn't going down the track. And I suppose I was also going down the track because there was no system of payment for the judicial review.
No system of
Payment.
Legal aid.
No legal aid.
Right, no legal aid, yeah.
So, and I wasn't quite sure really what the system of judicial review was, which we ultimately got Justice Haynes to say we should adopt the English system, which seemed a little perverse given we'd adopted holus polus the criminal system of New Zealand, but now we're adopting the English system, the difference primarily being that you don't need leave in New Zealand and you do in Pitcairn, and given the unsophistication of the Pitcairn population, trying to work out that you've got a judicial review in 3 months in a society without lawyers seemed a bit strange to me, and that's why, but we did file a judicial review ultimately, as it was a good exercise in actually drafting the statement of claim so you could see what points had been raised in the criminal proceedings, and then the Justice Haynes made his judgment in the criminal proceeding. And when the Court of Appeal said, well, why haven't you brought a separate appeal? I said, well, why should I? Because he only gave one judgment. Why should I have to do two? And given the absence ever, in living memory anyway, of a hearing of judicial review in the Pitcairn system. It seemed a bit strange to need to go down that track.
But forgive me, if you're right, the line that you were taking in front of these various judges and in due course in the Court of Appeal on effectively what are case management hearings about the impending criminal trial.
Yes.
Yes? You are asking for preliminary rulings to the effect that, and if you'd succeeded, the trial would not have taken place. Because if you're right, what you've been saying to us is the entire system is rotten to the core and there could be no criminal trial based upon it.
Yes.
Well, I mean, if that's right, then you succeed in obtaining a ruling in the criminal proceedings which aborts the trial, don't you? You don't need judicial review, do you?
Yes, I accept that, but the absence of judicial review is a systemic matter of great importance because
It's another indication of the errors of the system.
errors of the system and the totally unacceptable insulation of the government from accountability in the
If
legal
you're right,
system.
they're not immune, are they? If you're right, their efforts to prosecute the unfortunate Mr. Warren will fail.
Yes and no. It's not everybody who's going to do 60 days argument on some child pornography, is there?
The judicial review is not going to be shorter, at least, unless you have some completely different approach. Why should there be a different approach?
Well, the first issue was no system of judicial review, and we know in MacLibel, Steele and Morris, the big MacLibel defamation case,
Yes.
Strasbourg Court, that you need legal aid for cases of complexity. Well,
that simply means that judicial review would have taken even longer because there wouldn't have been legal aid. So,
well, yes, it may have been, but then that in itself would have been an important legal principle to establish, wouldn't
again,
it?
but it doesn't show why you need judicial review at all. That's my Lord's point.
Well, you need judicial review because it is impermissible in a modern democracy or a modern society such as this to not be accountable to the public of your, call it nation, state, island, whatever. So that's really the simple point there, and seems to you seem to. Sorry? Yeah, I'm on 128, luckily. Lack of democracy. Well, you probably grasp this without me needing to say a great deal about it, in that my proposition is simply that you can't set up the constitutional framework that you have here by merging the governor as in the executive and the legislature, even given this is in a Pitcairn ordering council, because you've still got to address the question of a universally elected house of one description or another, which the Supreme Court decided in the Barclay case, that one house must be universally elected. And we've got no houses that are universally elected in Pitcairn.
But that's in the context of the European Convention, wasn't it, in Barclay? And that doesn't apply here directly.
No, I think I'd like to disagree there, because the Pitcairn Constitution is a modern version of the European Convention, so it does. And
aren't you going in circles though? Because you can't use the Constitution to challenge the Constitution. The Constitution has in it the elements which you describe as undemocratic, namely the governor is the executive and to a large degree the legislative, and the Island Council is although elected, not a decision-making body.
Well, I'm not sure that that's right.
It's an advisory body.
Yes, but I'm not sure that it's right to say you can't use the Constitution to challenge some other provision of the Constitution. I know that might not sound very logical, but Section 26 says apply this part to the other parts of the Constitution. Let's just have a look at it. In Volume 9...
Legislation can't refer to the Constitution itself, can it? Or perhaps it does.
Well, it must do, because what else is it but legislation?
But that only is a compatibility requirement, and if the Constitution is flat incompatible, there's nothing you can do about it.
No, I don't think I agree with that, because we have to look in a wider context. 26, as far as possible, legislation of Pitcairn must be read and given effect in a way which is compatible with the rights and freedoms set forth in this part. And if we pause for a moment and look, for example, at paragraph 596 of my submission, and we've got the Bill of Rights 1688, which appears to be in force all over the South Pacific and Australia and New Zealand, but it's not in Pitcairn. And we have in that...
Well, you say it's not in Pitcairn. I think you say it is in Pitcairn in force.
Well, I say it is. Yeah. The courts of Pitcairn so far have said it isn't. And I say, well, that's wrong, because the Bill of Rights, Magna Carta, the Act of Settlement, the four pillars, habeas corpus, I think is the other one, four pillars of the unwritten Constitution have to be considered here too. So we've got, for example, there, freedom of election. The election of members of Parliament shall be free. Freedom of speech, and you no doubt familiar with the many cases under Section 9 of the Bill of Rights about what you can and cannot say in Parliament, and frequent parliaments. Well, where is the abolition of those rights in the modern Constitution? And without expressing in clear and express words that you're repealing fundamental rights that have gone back to at least 1688, you can't do it in the modern day Constitution. It's anathema to what the Constitution says, and the Constitution, of course, uses the term free and democratic society. I think it's 8 times, and then it doesn't have a free and democratic society. It's perverse. There's no other way of describing it. The legislature has followed the Foreign and Commonwealth Office, who have used this form of wording for other constitutions, and nobody's really given it much thought. But when we get to Pitcairn, we get the amalgamation of the separation of powers by the legislature and the executive branch being merged, which is antithetical to democracy. So we land up with a situation where the governor can make laws, doesn't have to pay any attention to the Island Council, and the upper house, analogously, is the Secretary of State in London, who can disallow too. So we're far removed from democracy, and remembering that the island is supposed to be held, according to the UN Charter, for the paramount interests of the islanders, not for the paramount interests of the Foreign and Commonwealth Office. So it's a somewhat weird situation to arise. And the Grand Chamber at 609 in Tennessee, if that's how you say it, the court has consistently emphasised the importance of Article 3 of Protocol 1 and its effective democracy, and it's of prime importance. The court held that free elections and freedom of expression, and particularly freedom of political debate, form the foundation of any democracy. Well, we've just abolished all those by an order in council called a constitution. Well, it's far from what one imagines in a modern day society what a constitution is. It's not democratic. And why merge the two propositions and then further limit Pitcairn's rights in the international arena by not allowing a further go at Strasbourg or Geneva? So and the Grand Chamber does, of course, say at the top of 145 there, you've got to look at it in the light of the political evolution of the country involved. But the whole concept of democracy is what underlies not only the European Convention of Human Rights, but also the International Covenant on Civil and Political Rights. And this is just adverse to this whole process. So I say you can use the Constitution with respect to strike down that part by using section 26 to strike down that part of section 36, which is inapplicable, or even if you can't, you use the Bill of Rights Act 1688 to do that.
But that is flat contrary, isn't it, to Lord Denning's analysis in Sabally of the significance of the Victorian statutes which were subsumed in the British Settlements Act 1887. He treats those sections, that legislation, as effectively entitling the Queen, by order in council, to start afresh as Parliament could with a clean slate and introduce any type of institutional law or constitutional arrangement it wished. And that's how it was interpreted in Banku, wasn't it, as giving as liberal a power as Parliament has. And surely Parliament can enact a non-democratic system, if one calls it that, or a system which at any rate has a limited democratic element, and did do in quite a lot of the settled overseas territories, didn't it? And well, gradually more democratic, in some of them, more democratic ways were developed.
Yes, but we're not in the 1840s, and with all due respect to Lord Denning's views, if you consider them in the light of the public law commentators saying this is the medieval change,
yes,
we've got to come into the 21st century, and we've got to have a realisation that, well, the British government, I'm at 551, says all the overseas territories work to the principles of the European Convention on Human Rights. And the Venice Commission on democracy, alongside human rights and the rule of law, democracy is one of the three pillars of the European constitutional heritage. It's inconceivable without elections held in accordance with certain principles that lend them democratic status. So we've moved on from Lord Denning's day. We're in the 21st century, and you've got to view it in those lights, because there are now international conventions, and certainly Sabelli doesn't say, look, we're considering the International Covenant on Civil and Political Rights or the European Convention. It's old law, and you've got to suggest a modern approach to this and move with the times. And and at 557 there, it's inconsistent to not have democracy when the words used in any of those sections of the Constitution, Section 8, the fair trial right, Section 11, privacy and family, 12, freedom of thought, 13, freedom of expression, 14, freedom of assembly and association. Why do these words? Let's just look at one of them, shall we? 13 is probably one, because we've looked at that before. Well, I'm looking at 12 because I can see it 12.2.
What page?
2885.
Right.
Freedom of thought.
Yes.
Such limitations as prescribed by law are unnecessary in a democratic society. And that phraseology appears throughout the Constitution. So there's obviously an intention there to be democratic, but the language is not reflected in Section 36 by abolishing, effectively, democracy. And there should be, and there should have been, discussions about what the effect of the Bill of Rights 1688 has, and
Right.
I do not accept that it's not in force in Pitcairn. And each and every right that is in the Bill of Rights needs to be categorised and said why it is not in place, which it wasn't. And you arrive at really an absurdity with 8 propositions about as is necessary in a democratic society, and then you produce a non-democratic society. And the Court of Appeal said there, 558, it's the smallest population of any democracy in the world. Well, that really misses the point entirely, because it's not a democracy. It's a benign dictatorship, where the governor is a walking and benign dictator, can do anything. And it doesn't accord with Articles 1 and 73 of the UN Charter.
How often does the governor actually visit Pitcairn?
A governor and a deputy governor, past deputy governor, are here. I don't know the answer, but I'm sure they do.
Right, well, perhaps we'll be fed the answer.
Yes.
I think the suggestion in some of the earlier judgments was every few years for short periods.
Every few years for sure.
Every few years, right? Yeah.
There does seem to be a genuine desire to keep in touch with the island and cooperate as fully as possible by both the governor and deputy governor.
But I mean, there are lots of circumstances in which there is either no democracy because there are political inhibitions against developing it, e.g. Hong Kong, or there are no democracy because it's necessary to suspend the constitution, which is done by order in council, as in the Turks and Caicos Islands. So even when you've got a constitution that incorporates many of the provisions of the Human Rights Convention, ultimately this is subject, in the case of a Crown colony, to the decision-making power of Her Majesty and Council.
Well, I would agree that there are circumstances when democracy is put to one side, and
It may be impossible to achieve. Possibly with a population as small as 50, one's presented with certain practical difficulties about democratic institutions.
well, it managed quite well until a small proportion of the male population abused females, and it was left alone for years to run itself, and it didn't collapse, and then the British government moved in to ensure the rights of the females that were being abused.
I'm not sure what you mean by managed quite well. I mean, your thesis is that the whole system is defective.
Well, it didn't have a constitution that said the governor.
I see. So they introduced the constitution then.
They carried on
Yeah.
managing their island by
Yeah.
themselves without any effective interference from
Yeah.
London.
You don't have to, but do you want to say what form of democracy would pass the test that you have set? This is an island with how many people?
50.
Is that adults or 15?
No,
50
no,
include
it's
It's 50 in total, isn't
50,
it?
right, but I think there's only
30 working adults we're told.
there's
Yes.
very few
Okay.
children who move off.
Anyway,
at
given
30.
that, what form of democracy would satisfy the
and-
test that you say we should set?
Well, there would be the council, the island council, would be elected and have law-making powers, which, according to the Sark proposition, the Sark case, I think, could be subject to review by an upper house, a Secretary of State or whatever. So
Secretary of State in London.
yes, because there's going to be things like defence and
Yes.
national security and the like.
You're advocating really a sort of Channel Islands model,
Yes,
because the Channel Islands has a limited legislative power locally. It has to get the Privy Council to endorse anything of that nature.
The same is true of Crown colonies with their own legislatures. They have to be approved by the Privy Council too. I think they do, yes.
Yeah.
I mean,
yes.
Anyway, we've got the sort of picture,
Got a
and I think it's...
Well, I did forget to comment on Hong Kong, even whilst it might not be a democracy in the sense that we mean it, it nevertheless has a better Bill of Rights and incorporation of international human law rights than even New Zealand does. So it's an improvement simply because you're not a democracy in that traditional sense, doesn't it? And it has Sir Anthony Mason, or it did have, as a non-permanent judge on the final Court of Appeal and so on. So there's input from others. There's any possible numbers of possible solutions. But to my mind, the Sark ordinary Guernsey approach is where, if that answers Lord Hugh's question, and I've got 10 minutes, okay. So in Barclay there, which is at page 136, we've got on my page 137 there, we're looking to, the Human Rights Committee are told by the United Kingdom government that we're expecting to improve the rights contained in the covenant, except to some extent Pitcairn and St Helena.
Where's that?
On page 137.
Yeah, fine.
The consequences are especially regrettable in those overseas territories of Pitcairn, whose constitutions do not contain chapters on fundamental rights,
Right, yes.
and so on. So back in and the committee.
Well, they do now.
Yes, yes.
They do now. They've hotted up the constitutions.
And
Now, can I just ask you, I mean, the points we've been discussing most recently, lack of democracy and general complaints about lack of a system of judicial review, fall outside the scope of Part 2 of the Constitution, don't they? They're not complaints relying on the fundamental rights parts of the Constitution, or are they? Because I make that point because you've only got leave to appeal as of right in respect of points under Part 2 of the Constitution. In other words, Section 25 objections. You haven't got general leave to appeal, and I don't know whether you're applying for leave but there are certain tests which we apply if you're having now to apply for leave in respect of a particular issue. You're probably familiar with them. I mean, it's not only got to be arguable, it's got to be a point of general importance. Now, I suspect you would say that a point going to lack of democracy is of obvious general importance, but I just make you aware that you need to address that.
Yes, I have addressed that in my submissions by saying that I'm aware of that, and if I need leave, I seek it. But I take the position that I don't need leave because you can address all these points in the lack of a fair trial, because if you haven't got a system of justice,
I see, yeah, no, that's...
it goes to the fair trial, and that's wide enough to incorporate it all. But I have flagged that if you don't agree with me, I'm seeking leave.
No, that's helpful.
And then my learned friend...
I mean, why, just a matter of interest, why does lack of democracy undermine a fair trial?
Well, because the whole structure of the island and its political process has been undermined in that you have no way of participating in public affairs. So we're in Article...
But why does that affect
25.
the validity of your client's conviction?
Well, it's the systemic point that we've got no...
But it doesn't go to the fairness of a trial, whether there is a legislature.
Well, I suggest that it does, because...
Where's the connection?
Because the laws that are passed to make the trial fair have not been passed by a democratic legislature.
The proposition is what? That you can only have a fair trial in a democracy.
Well, I can see problems with that. We've got another case from China, extradition for murder, and saying you can't get a fair trial in China, and that's been going for 6 years. And the covenant says, yes, you've got to be able to have a fair trial, right to a lawyer, and so forth. And if you haven't, it's not a reasonably fair trial, it's absolute. And that's really where I go. I don't say that you can't have a fair trial in a non-democracy, but it doesn't fit the international requirements of Article 14 of the Covenant, because the general comments of the Human Rights Committee make that quite clear. So, though in practice, it may well be that you can't have a fair trial in some undemocratic countries, Syria, Iran and so forth, but that's probably about as far as I can take you with this. If I could just wrap up by leaving ground 4 to my learned junior in the morning, 146 to 155. Ground 5, I anticipate a little by endorsing what he says too, and then just saying there's a totality argument. Costs were legally aided except for the judicial review, and then there's the summary of the argument. So I'm grateful for being listened to, and unless there's no questions, I think I've made 3 o'clock with 3 minutes to spare.
I'm not sure, Mr. Ayres, you've dealt specifically with the section 160 point, which is at 391. Is that coming later?
391?
All right.
Yes, my learned
It's coming
junior.
later.
My learned junior will deal with that in the morning.
Thank you very much.
Let's have a look at that. Yeah. Good.
Thank you.
Thank you very much indeed. Well, shall we resume tomorrow morning at 10 o'clock then? And
I might need 2 minutes in the morning to deal with the 2 questions I haven't answered that you asked earlier. The judicial control over the bar, was it argued before? And said in my paragraph 167, 116, 170. Those, you asked two questions before.
Yes, there were one or two points you were going to look at.
Yeah, I haven't found the answers yet because my computers, well, I'm incompetent to interrogate the computer.
I mean, you've dealt with Ferguson, have you, sufficiently? You were going to deal with the question whether it's a new point that the Chief Justice had power to appoint the bar.
Yes.
Two new points.
And a new point, yes.
Yes, so I'll deal with those very
Also,
briefly in the morning.
Whether the
Swearing-in point.
whether the notice to Mr. Warren and others of the
Privy
proposed
Council.
making of the order was a new point.
Yes.
And the swearing-in
I
point.
think the swearing-in point was also
Yes.
the public swearing-in.
Public swearing
Seems to be a
in,
new
I think, may have been a new point, but I think you think it isn't.
Well,
It's said to have been a new point, and
Yes.
really, if you took the point below, tomorrow
Is the time to tell
is
us
the
when.
time to say when and where.
Right.
yes.
Right. Well,
Thank
then,
you.
thank you very much indeed.